I'm a client. I make $100K a year. My wife makes $50K a year. I got 2 kids. Tell me what you do.
Well, more information. First off, how long were you married?
Married 5 years.
That would make a difference. And 2 children. And when did you separate? Are you separated?
Been separated for 2 years. Married 5 years ago.
How old are the children?
All right, let's say the kids are 3 and 4.
Okay, and you're separated how long?
Been separated for 2 years.
So the 3 and 4. All right. Depends on who has custody of the children, assuming that with the age, assuming in Virginia the mother would get custody and the father would have to be paying child support. Child support would be calculated based on father's total gross income from all sources, mother's gross income from all sources, the amount of the health insurance, but only the portion for the children, which is defined as the family plan minus the individual plan, and that's only the health care. The amount of that child support would be calculated fairly quickly once those 4 numbers can be provided to the court. So typically the court would ask for W-2s or tax returns to show sources of income. The parent who is paying for health insurance now needs to go to their employer, their health, their human resources department, and get that calculation. If they're paying now for the family plan, they need to know how much would it cost to pay for an individual only. And they have to get that number from human resources, and then the difference, family plan amount minus individual amount, that difference is the amount of child support that's included in the calculations. And then those numbers are relatively straightforward and easy to get. Then the difficult part, or the part that opens itself up to manipulation, is the amount of work-related daycare. So in this example, both parents are working, so presumably the daycare would be necessary to allow one of the parents to work, but then you need to look into the amount and whether it's even being paid at all. So a lot of times the one parent will say, this is the daycare that I'm going to get, and they always select the most expensive daycare center in the area. Or they'll say, my mother is taking care of the children and I'm paying her $1,000 a month. Well, that has to be proven. It can't just be an amount that one of the parents says. I've also sometimes subpoenaed that third party in order to verify an expense or verify the income. So we want to, if the mother is the one doing the daycare, then we want to subpoena the mother and get her income. So she presumably is making $12,000 a year, which means she has to report that on her tax returns, probably as a Schedule C. We'd also ask for the parents' bank statements to show that the money is actually being paid. The reason that daycare is important is because that would move the number quite a bit. So fluctuations in income do not move the amount of child support that much. Different amount of health insurance does not move the number that much. But what really moves the number is the change in the amount of work-related daycare. So a lot of times it's easy to come up with a much larger amount of daycare or a much smaller amount of daycare if one parent is willing to lie about the amount of daycare that they're paying now or that they're going to pay in the future. It's unlikely that there would be alimony. There could be a temporary assistance on paying the debts or staying in the marital home. One parent the father might be ordered to pay the mortgage payment or pay the utilities, their whole work life ahead of them, so that there'd be probably no need for rehabilitative alimony. Is an amount of alimony could be paid over the years, could be paid in a lump sum in order to have that spouse get back to where they would have been if they never got married. The classic example would be a woman who drops out of college, to support her husband going to medical school. She's out there working, the husband's going through college, going through medical school, and then when the husband becomes a doctor, he divorces his wife. So that's where rehabilitative alimony would be appropriate, because the mother, or the wife, would want to go back to school and finish up her education, which she would have done but for putting the husband, or helping the husband get through medical school. I'm assuming that there would be very little in again, short-term marriage, young couple, they probably have very little marital property, and so that there would be very little for the court to divide. Whenever you divide marital property, the more you can do yourself, the more you save. So you do not want to fight. You don't want to pay the lawyers to fight over household goods or even the car. So whatever you can divide up yourself, get that done without the lawyers, without the court system being involved. And again, with in this example, a short-term marriage, I'm assuming there would be very little built up as far as any retirement plan. So any retirement money that either parent brought into the marriage belongs to that parent up until the day of the marriage. Anything that was added to the retirement plan during the marriage, that would be marital property, and that would be divisible, that's property the court could divide. So if there's a pension plan that's started before the marriage and continued during the marriage, then you've got both separate property mixed in with marital property, which they call hybrid property. And then those calculations can get very difficult, because you have to go back and find out what was in the pension plan on the day of marriage, what's in there today, how much money are we talking about. 5-year marriage, probably not that much. So in that situation, it might be more efficient just to let one spouse keep the entire pension plan and make a payment over here with assets that are not part of the pension plan. Nowadays, the pension plans usually charge money just for writing these orders, just for dividing it up. So you might be spending $500 to the plan and another $500 to the lawyer to draw up the order to divide the plan. And so a lot of times, instead of paying that much money, you just say, okay, one parent keeps it and the other parent gets an adjustment someplace else. That's more efficient, and also it can happen right away. It will take a while for a pension plan to make to actually split the pension plan, so the wife gets part and the husband gets part. As far as the cars go, you didn't say in the example, but I'm assuming there are cars. Since they both work, I'm assuming the husband has his car, wife has her car. Again, cars are assets that the parties should divide between themselves, if at all possible. And there's usually language in the court order or language in an agreement that both sides will cooperate to sign whatever papers are necessary in the future. Like with the Division of Motor Vehicles would have forms to relicense or retitle the cars, that kind of thing. If there's loans on the cars, then the loans stay on the cars. So even if one spouse got the loan on the car, that loan's going to stay on that car until that loan is paid off. The lender, Ford Motor Credit, they don't care whether you get divorced or not. All they're looking for are the payments made on time? That's it. Things get very complicated if one of the spouses is self-employed, or if this one parent lives a great distance from the other parent, then you're going to get into custody, and that can be a major problem. So assuming the parents are living or will be living separate, if they're living near each other, then there is a kind of a standard visitation. It's not mandatory, but it's what the court starts with, and then the parents can argue to change that. So in this example, the children are still relatively young. They may or may not be going to school yet, so they could spend more time with one of the parents. But once the parents start school, then the school schedule controls visitation. So the typical visitation would be the child or children would be with one parent every other weekend. So Friday to Sunday, and then one day, one afternoon during the week. So it might be Tuesday afternoon. The parent can pick up the child at school. They may go to sports. They may go to dinner, movie, do homework, go to dinner, and then that parent drops the child off back home. That's once a week, usually in the middle of the week, and then every other weekend. The standard visitation is also would alternate holidays. So if one parent has Thanksgiving 2024, then the other parent would have Thanksgiving 2025. The mother gets Thanksgiving every even numbered years, and then the father gets visitation every odd number of years. The mother gets the children Thanksgiving 2024, then the father gets the children for the first half of the winter break, then the mother gets the children for the second half of winter break, and then the father would get the children during spring break. So mother, father, and that would be the major holidays during the year. Father would get the children on Father's Day, mother gets the children on Mother's Day. Usually father gets the children on Father's birthday, mother gets the children on Mother's birthday. If there's religious holidays in there that are important, then that would be dealt with in the same way. Children's birthdays, the courts encourage everyone to have it together, so the whole family comes together for the children's birthday, which is nice if possible. And then during the summer, the non-custodial parent would get at least 2 weeks, and you would certainly argue and try to negotiate for a much longer. Now that's if the parents live nearby live near the children. If one parent is far away, then obviously seeing the children one afternoon per week is not practical, or seeing them every other weekend is not practical. So then that parent, the parent that lives far away, would get the children a lot more in the summer. And now with all of this internet and that the parents would be allowed almost not continuous, but very frequent virtual visitation, whether that's on Facebook or anything like Zoom or anything like that. So that leads to another problem, which is that during the virtual visitation, one parent might interfere with the visitation, especially if it's younger children. The parent could sit in the room, but off screen, telling the child what to say or glaring at the child so that the child doesn't become very affectionate to the parent who's not there. And so we can deal with that, require the child to be in a room with the door closed, have the camera pointing at the child, then with the closed door behind the child, you'd have the child pick up the camera and do walk it around the room so that the other parent can see the room is empty, see a 360 of the room, and then sit down with the camera pointing towards the closed door and have visitation that way. If a parent wants to make trouble, a parent is going to figure out a way to make trouble. If the one parent lives far away, the custodial parent could intentionally mess up the airplane flights, or arrive at the airport slightly late and intentionally miss the flight, and then the parent has to pay an arm and a leg for a new flight, a replacement flight, change of flights, that kind of thing. And of course all that delay interferes with the visitation that the other parent would enjoy at the distant location. Also, if the parents are living apart, there's also battles on who's going to pay for transportation. Does one parent pick up the child at the house? Does the custodial parent deliver the child to the other parent's home? How does all that work? Who pays for the plane tickets? Who pays? If the child is young, you may have to hire an escort, someone to ride with the child. You go to court, rule to show cause to enforce the visitation order, and the judge then would rewrite that little portion of the order in order to make it to solve that problem at least. There is a concept also in visitation, or in I guess custody now, that's called a tiebreaker. So the parents may start off with joint legal custody, meaning each parent makes a decision as far as the how the child is raised. But if one parent disagrees, then what do? You just have deadlock and no one can make a decision? And a lot of times the courts will say, okay, if there is a deadlock, if one parent wants to do this, one parent wants to do that, then this parent gets the tie breaking. This parent's decision will be what's done. You could have, again, shared, that would be a situation of shared legal custody, but one parent has a tiebreaker. It could be a tiebreaker on everything, or it could be a tiebreaker only on, let's say, vaccination, only on extracurricular activities, medical treatment, or which school they would go to.